I have two articles to do to talk about what's going on in Arizona currently. Okay, so this one is from Axios and I have one from Vox. Arizona House again blocks the repeal for the 1864 abortion ban. Senate leaves the door open. The Arizona Senate took a concrete step towards repealing the state's pre-Roe abortion ban on Wednesday, but the House Republicans continued to block similar efforts, leaving the fate of the 1864 law in question. The big picture: the razor-thin margins 30-30 in the House and 16-14 in the Senate illustrate the tensions that have resurfaced over the issue since the Arizona Supreme Court reinstated the pre-Roe ban last week. In total, 3 Republicans in competitive districts joined Democrats to support the repeal. And obviously, they're trying to straddle the fence and act moderate because this is a hot button topic. Attention now turns back to the House, where the Republican Speaker has vowed to continue to stymie the effort, driving the news. The soonest the Senate could take a vote on the bill is in 2 weeks due to the legislative procedures. The Senate Republicans' communications director, Kim Quintero, told reporters on Wednesday. It would also take the House at least another 2 weeks to give the bill final approval because both chambers are meeting only once a week. They reconvene next Wednesday. So this is how slow this process is to change a law, to make a law. It takes a lot, especially when one party wants to block stuff. House Speaker Ben Toma tells Axios he'll continue to block his chamber from voting on the bill if the Senate passes it, just as he and most Republicans have now done twice. Quite frankly, I don't know how it's different. The only way to force a vote would be to override the Speaker, which most Republicans have been hesitant to do. Even if it were to pass, without supermajorities, the repeal wouldn't go into effect until 90 days after the session ends, which has no fixed date. Last year's session, the longest in state history, lasted through July. The earliest the 1864 ban could take effect is June 8th. Democratic AG Chris Mays confirmed Wednesday on X. Therefore, the ban could still be in effect for an unknown period of time. Representative Matt Kress, Republican out of Phoenix, the only House Republican to publicly support the repeal, said he believes the others will join him if it goes up for a vote. Only one more House Republican is needed. But it's unclear whether other Republicans will go as far as overriding Toma, even if they support the repeal. Representative Tim Dunn, Republican from Yuma, one of 2 other House Republicans who were heavily pressured Wednesday to support repeal, tells Axios he thinks the ban should be nixed. But he wouldn't say whether he was willing to override Toma. He says he's committed to continue conversations with his caucus this week. Between the lines, Democratic Governor Katie Hobbs and Mays have pledged that the ban won't be enforced, but the providers are unlikely to provide illegal abortions regardless. Mays said Wednesday she would fight like hell to prevent this law from taking effect. She also discussed with the California Attorney General the possibility of obtaining emergency licenses for Arizona providers. So that is what's going on. Everything's still in flux, and Republicans don't want to bring this to a vote because they know that this is a hot button topic that has major implications. Now, how did we get here to where we are even talking about a Civil War era abortion ban? Let's look at the history, and Vox wrote about this. The history of Arizona's Civil War era abortion ban, how conspiring doctors, questionable tonics, and twisted patriotism led to the 1864 abortion ban in Arizona that was recently upheld in court. I'm going to skip the part where it's talking about Republicans don't want to bring this up for a vote because I already went over that in the first article. Democrats in the chamber, as well as both former President Donald Trump and Republican Senate candidate Kari Lake, in an election year shift toward a more moderate stance on abortion, have pushed the Arizona legislature to overturn the law. Motions to debate legislation to overturn the law have been 3 times, and each has failed. If lawmakers do not reverse it, the law could go into effect in the coming weeks, threatening access to reproductive care for about 1.6 million people. Now, the important thing to know about this is a hot button, and they are looking to put this on up for a vote come November. And this is going to push women to vote. This is going to get people off the fence and push them to go vote. Anyways, let's keep going. It's one of the several abortion laws enacted before the Supreme Court's 1973 decision in Roe v. Wade that have been revived since justices overturned Roe in 2022. Resuscitating these laws has created legal headaches, in part because they were written in a very different time for reasons that have little in common with the concerns of forced birthers today. Arizona's ban, first passed in 1864, codified again in 1901 and 1913, says anyone who provides, supplies, or administers a abortion or abortion drugs will face a state prison sentence of 2 to 5 years unless this abortion was necessary to save the person who is pregnant. Taken out of the 19th century context in which it was passed, that language would seem to amount to a near total ban. But that's not how the law was originally enforced. Few people were prosecuted under the Arizona law or similar ones in other states. At the time, first trimester abortions were widespread and widely accepted in the public conscience. It didn't turn into what we see until the moral majority took over the Republican Party in the 1980s, well, the end of the 1970s, and when Reagan was coming into office. Abortion laws of the mid-1800s were the product of discussions among lawyers and doctors and were designed to professionalize services in medicine writ large, a seemingly noble cause, but also one driven by physician self-interest and the desire to have more white babies, and weaken the nation's feminist movement because feminists wanted women to have more control over their bodies. There was no national abortion debate to speak of. Religion wasn't yet a major factor in American views on abortion the way it is today, and scientists had not yet developed methods to detect pregnancy in the first months of gestation. All of that meant abortion was a common, if not always safe, part of American life, despite what the old laws might suggest. I think people imagine nobody did it because it was illegal, but we know that's not true, said Lauren McLevore Thompson, a history professor at Kennesaw State University, focusing on women's rights and public health. Abortion was common and widely accepted in the 19th century. For much of the first half of the 19th century, there were few laws in the U.S. that were specifically concerned with abortion. Rather, abortion was understood in the tradition of British common law. It was only a crime after quickening, when a fetus's movement could be detected around 4 or 5 months of gestation. Before quickening, people could be ignorant or have plausible deniability about being pregnant. Generally, the American public at this time had few moral qualms about abortion before quickening. In particular, it was a service that many believed should be offered to unmarried women who risked reputational ruin if they proceeded with the pregnancy and often came from poor backgrounds, as historian James Moore writes in his 1978 book, Abortion in America. But around the mid-1800s, things started to shift. More people appeared to be seeking them, not just those who were unmarried. One estimate by physicians at the time that more sites suggest that as many as 1 in 5 pregnancies ended in abortion. Partially because of this, birth rates fell dramatically from 7.04 children per woman in 1800 to 3.56 by 1900, according to Moore. So the birth rate got cut in half. Starting around the 1830s, abortion became a lucrative industry. It was still largely unregulated, but perceived as largely safe, especially when weighed against the risk of pregnancy. There's also little available data on maternal mortality rates in the U.S. at the time, but even by 1915, after the development of antisepsis, it was about 600 in every 100,000 births, higher than some European countries at the time. In 2021, the U.S. maternal mortality rate was 32.9 deaths per 100,000 live births. So that's, obviously that is a dramatic difference. So the beginnings of the anti-abortion movement, That started around the 1850s. For one, forced birthers resented the fact that wealthy white Protestant women were starting to drive the demand for some abortions. So more white women were having some abortions, so they had to cut that out because they wanted that birth rate to continue to be up. These women were seen as shirking their duties to Republican motherhood, a concept that involved raising the next generation of productive citizens instilled with the values espoused by the young American Republic that excluded non white women. They were maligned for indulging priorities outside of the home at a time when women's suffrage movement was taking shape. Some men were seen as complicit in this phenomenon, urging their wives to get some abortions and pay for them. So this is all has always been all about white women's birth rates and making sure that it's more than non-white women's birth. Anti-smomortionists argued that laws specifically restricting smomortion were necessary because otherwise, nice white ladies who don't want to be pregnant just won't fulfill their obligation, as McLevore Thompson put it. Around this time, there were also a few highly publicized trials involving botched smomortions, typically cases where the pregnant person died. This raised the profile of smomortion as a safety issue for legislators. A broader movement to professionalize the American medical system also contributed to the first laws restricting abortion in the U.S. The Civil War laid bare the need for more competent medical professionals and credentialed physicians known as regulars. Lobby for laws on abortion for the stated reason of protecting people from quacks. But they also had selfish motivations to essentially establish a monopoly over the market for abortions and sideline their competition. Physicians, who at that point were nearly all white and male, had lost income and stature as a result of this competition with other medical practitioners, and performing abortion was a way to attract long-term patients more right. So this is the part that's important. What they're trying to do is consolidate their professional dominance because they don't want to be competing with midwives or competing with what they call the irregulars, McLevore Thompson said. This was despite the fact that she added that the outcomes that doctors got in terms of treating patients were really not that much better than people who didn't have medical training. And this goes along with how they kept out midwives of the birthing experience. They tried to consolidate it to where this was a white man's profession, and they wanted all of the money. So even though midwives had the knowledge to do all of these things, these people tried to keep them out. So that is the history where many of these laws came from. It was mostly to keep people out and be a money grab for these doctors. Okay, I just wanted y'all to see that. You guys jump in the comments. Let me know what you think about this. And don't forget to like, comment.